Good morning, everyone. Welcome to the First District Court of Appeals. We have 3 cases to be argued this morning. I'm going to read through the cases. If counsel could just identify yourself and indicate your readiness to proceed. First case is Ma versus Cincinnati Children's.
Mark Meisbach for Dr. Ma, we're ready to proceed.
Okay,
That's Brian from Children's Hospital. We're ready.
thank you. Next case is State versus Gibson.
David Hoffman for the appellant, ready to proceed.
Okay,
Joseph Cousin for appellant, ready to proceed.
all right, thank you. And then the final case is State versus Hill.
Laura Peters for the appellant, ready to proceed.
Connor Wood for the appellee, ready to proceed.
All right, thank you. Each side will have 15 minutes to argue. We'll keep your time, and with the light system, yellow means you've got about a minute left. And Mr. Meseval,
Thank you.
would you like to reserve any time for rebuttal?
Would you want to go ahead and reserve 4 minutes, please?
You may.
Good morning. May it please the court, counsel. Once again, I'm Mark Meisbach for Dr. Ma. Your Honors, the genesis of this dispute relates back to 2014 or so, when Children's adopted a new business model wholly predicated on a faculty's ability to maintain financial sustainability for their research agenda. The problem with that model was that it completely abrogated, at least in this instance, the institution's promises and commitments to Dr. Ma. In a previous case, this court is familiar with, Children's contended that there was no contract between the parties. But the court rejected that argument and determined that Dr. Ma was entitled to tenure according to offering him continued employment absent just cause for his termination. Fast forward to this case. Children's has done a complete about-face, now argues that there is indeed a contract. It entitles Children's to fire Dr. Ma with just cause if he fails to sustain his research agenda. According to Children's, this is a unambiguous, discrete contract about which there's no dispute as to its terms and conditions.
So how would you define just cause?
Well, I would just cause, I think, as the Supreme Court of Ohio defines just cause, and the Irvine case, I think, is the most applicable example of that. And I think what they're telling us is that just cause is actually ambiguous. There is no hard and fast definition in the law, certainly not in Ohio, with respect to the definition of just cause. So what the court informs us is that you have to look at the particular facts, the context of just cause. And I don't think anyone would disagree with the proposition that just cause to terminate, let's say, a factory worker, or in that case, I think, as a hospital aide, differs entirely from just cause to terminate a research tenure professor at an educational institution. You make that determination, especially when there is no concrete and explicit definition of just cause in the contract, based on context, based in facts and circumstances. And as this court, I think, knows well and has instructed us, where the contract itself is silent as to definition of a specific term, as it was in the previous case with respect to the term tenure, you look at extrinsic evidence. This is what the court said about contracts back in our prior case.
Counselor,
Yeah, we're familiar with that.
All right.
On the record before us, did the parties have a meeting of the minds that just cause in the context of their relationship means intentional misconduct?
I don't think they had an explicit meeting of the minds on that, but that was certainly implicit in the context of the employment relationship between Dr. Ma as a researcher and as a tenured researcher with the university. And that was, as Sandra Degan testified, cause or fault, not cause, but fault is part of the definition of just cause. In other words, you don't terminate somebody because he or she failed to make her research or his research numbers. But if he failed because he's failing to do things, not doing things, or acting with misconduct and an intent to harm the institution, then of course
So if
it's
we
just
agree,
cause.
if we agreed with you and we sent it back for a trial, how would the jury be instructed on just cause?
I believe they'd be instructed by, in accordance with what I said about the Irvine case. They have to look at the facts and circumstances and determine from those facts and circumstances, inclusive of extrinsic evidence, what is the understanding between the parties as to what just cause means. That is intelligible. It is understandable from the circumstances of this case. First of all, we start out with Sandra Degan, who was the person most knowledgeable about what these obligations back and forth between the university and tenured professors meant. And clearly, she has testified that just cause was not an explicit understanding. In fact, she testified both at her live and in her affidavit that there was no explicit and clear definition of just cause. In fact, no professor had ever been terminated from the university for just cause because he or she failed to meet some requirements. As a matter of fact, I think we can put that situation to rest if we look at testimony of Pete White.
Before you get to that, I want to ask a question about the two different offer letters. So we had the 1992 offer letter when he first came to the university, and then the 2007 letter, which apparently was to induce him to stay, correct?
Correct.
How do those two work together? Did the 2007 one replace the 1992?
Well, it's a good question. I think in some respects it didn't replace the 2007 because Dr. Ma had already had tenure. And it was agreed, and I think Dr. Strauss testified, we never got into the issue of tenure because it had already been determined that he had tenure. So we're not touching that phase of your employment. But with respect, and what they did do is gave him a raise, and they gave him a new title. They assigned him a new location for his work. They talked about sustainability, as they always do, because that was an aspiration for all researchers there. But they also clearly separate, and this is what's interesting about the argument of Children's, that there's a clear, unambiguous statement of just cause with respect to sustainability. If you look at the document, the 2007 document, for example, it clearly makes a difference between an employee's obligation to sustain his agenda with respect to research costs, as opposed to the university's obligation or the institution's obligation to pay him a salary. In fact, the 2007 has two distinct sections, if you will. That's the way I look at it. At the end of the first page, they say, we cannot guarantee funds to maintain the operation of your laboratory should we have a funding gap. There's no...
Well, and help me understand, like, how much of Dr. Ma's time was devoted to teaching versus research?
It was mostly research, and I think the percentage was like 80-20 or something.
But so if the question is providing funding, getting grants to sustain the research, and that's not happening, that whittles down his effective working time to like 20%, right?
Well, but in this particular case, that's a hypothetical I think that the court has posed to me, because in fact, Jun Ma had funded his research at 100%. In 2015, you can look at his performance evaluation, he was at 100% of his requirements to fund his research. So that never happened. But if...
Well, what about, like, I'm looking at this chart in your opponent's brief that shows, I don't know, 30% or something in this really dramatic...
That was his, yeah, I know, that was his salary. It was 28 or 30% of his salary. But, you know, you can go back to these two seminal documents, the 2007 and the 1992. There's clearly a distinction between research monies to conduct your research and salary. In fact, in 1992, they told him your salary and your funds were guaranteed by us. That's explicit.
Did that clause, did that survive the new offers, the the 10-year offer and the 2007 new offer?
Well, it's an interesting question because I think the best answer is the history is ambiguous. So we have to look at external evidence. And what we know is that a failure to fund does not necessarily mean that you get terminated. And as I said, you look at page 63 of Peter White's testimony. He's the person who was Dr. Ma's supervisor and who fired him. And he was asked point blank, you agree with me that no other researcher has ever been terminated for absence of funding? He said, correct. And would you agree with me that a failure to fund does not mean that you're necessarily going to be terminated? And he said, correct. And then I said, well, how do you determine it? He said, well, I go back and I look at their histories, and it's clearly an ad hoc decision, not based on a clear and concrete and express obligation to support either your research or your salary. But from the get-go, the university assumed an obligation to pay him a salary, and that's clear from the 2007 letter, where they draw a distinction between funding and research. As a matter of fact, they said in the 2007, I believe it was 2000, no, I think it was 92, if you have obtained external funding. So if you obtain external funding, you're actually going to get a kickback on your salary. You're going to get monies back if you've. So there was always an obligation on the part of the university, the institution, to pay Dr. Ma's salary. And as Sandra Degan said, if you don't meet your research obligations, and Hostetler said the same thing, basically, in her affidavit. Your research agenda gets shrunken. It gets reduced. You'll have less people. You'll do less work. You'll produce less product, and your career will suffer. But it doesn't mean necessarily that you're going to be terminated, because every witness who testified, either from us or from the other side, testified that funding gaps were expected. No one said that was a terminable offense. Quite to the contrary, and all the extrinsic evidence tells us it never was, because there was a whole raft of researchers never made their funding.
All right, you are about at your time if you want to reserve 4 minutes.
I'll save my 4 minutes. Thank you.
Great, thank you. Ms. Bryan?
May it please the court, I want to start out by talking about the facts that are not in dispute here, because we're here on summary judgment. Dr. Ma's salary and the percentage of his salary that he funded through external grants is not in dispute. It's not in dispute that Children's fired him over his external funding. This is not a discrimination or a retaliation case. It's a straight breach of contract case. And it's not in dispute that from 2012 to 2015, where Dr. Ma is being told repeatedly by his evaluators that he is not meeting his funding obligation, that Dr. Ma applied for no external grants that could be used to fund his salary for a 39-month period. So he wasn't doing anything to meet his contractual obligations. Judge Berger, on your question about what would the jury instruction look like, I think tells the tale of what happens in this case. Whatever the instruction is on just cause is going to decide it. So it's a decision as a matter of law. The facts are not in dispute. It's just a question of did you meet
I think
your
like that
contract?
the definitional question though is complicated, because I know you all cited cases on just cause, but it's not like there's a uniform definition of just cause, and in fact there are cases that say this is a very fact-intensive inquiry. So and I mean, this is the problem obviously when we don't have a definition in the contract or in any sort of policy. How do we define it?
Well, I disagree slightly with you. The reason that just cause is so amorphous, right? You're looking at all sorts of situations in an employment context. But what the law says consistently is if you breach your contract can be terminated. And here, the contract is very clear. He had an obligation to sustain his research and his salary through external grant money. And it starts out right at the very beginning.
Well, but I want to push back on that, because like the notion, and you emphasized it in the brief about like this 70% funding or whatever the percentage was. Like, I don't see anything about that in the contract. I don't see any specific metrics. And if there were specific metrics, I think your argument would be much stronger, but persuade me on that.
Sure. So when you go back to the 1992 letter, and the beginning of the second page, it talks about, the bottom of the first paragraph talks about how Children's is going to sustain Dr. Ma's salary for the first 5 years. And then after the fifth year, he's going to be subject to the policies then in place for Children's Hospital. So then by 2007, the policy of Children's, even before then, but by 2007, the policy of Children's Hospital is that researchers like Dr. Ma, who basically have no other activities other than researching, have to sustain their salary with at least 70% of their salary through external funding. And that is in a host of the documents, including all of his evaluations from 2008 on, offer letters to other faculty members in the Division of Biomedical Informatics
All right,
also say 70%.
All right, so I want to press you on this.
Sure.
So his evaluations are not part of a contract. What was said to other faculty members is not part of his contract. So where in his contract or in an external policy that was incorporated into this contract does it say 70%?
I want to push back a little bit. His evaluations are part of his contract. When you look at the last paragraph, paragraph 10 of his 1992 offer letter, it lays out what the expectations are. The first sentence of paragraph 10 says, the expectation of Children's in return for giving this support is that you're going to run an independent research lab. And the evaluations of Children's are going to tell you whether you're meeting those expectations. So that last sentence of paragraph 10 refers to those evaluations. I think the other thing about this...
Part of your annual performance review relates to the quality of your research and the extent of success in attracting support for your program.
Right. The support in attracting your program. And it is very clear that he had to meet some measurement to sustain his funding obligation.
Some, but what?
Well, but we agree that we can look at what he was being told. I think the issue in this case too, my opponent has tried to put this out as there has to be some sort of written policy, and we have to point to some written document. And we're pointing to written documents that are showing what the policy is, and he's being told this repeatedly. Their argument is he had no obligation to do anything to fund his salary through external grant money. And so Children's Hospital could take away his lab, and he would have no work, essentially, because his teaching obligations were only for researchers that were working with him in his lab. He didn't have anybody else that he was doing. So according to them, his lab could go away, and Children's would have to pay him $190,000 a year for doing nothing. And that's not the deal that they struck. The letters are very clear about what Children's would commit for money to use for his salary and his lab. And by 2007, it was $150,000 a year. Your question about did that 2007 letter include the requirement that this offer was firm and it was Children's obligation to pay this money? I want to back up and explain that a little bit. Children's Hospital serves as the Department of Pediatrics for the University of Cincinnati Medical School. So when you're looking at that first letter with that sentence about the commitment is from Children's Hospital, that's in the context of explaining who is going to actually send him a check. It's going to come from Cincinnati Children's Hospital and not the University of Cincinnati Medical School, because there's some confusion. If you look at that first sentence, it's talking about how it's an offer from for tenure within the University of Cincinnati Medical School, and it's explaining that relationship and who's going to pay him.
Don't you think that's a little bit ambiguous, though? I mean, it says your salary and support are the responsibility of Children's Hospital. These are guaranteed by us.
Sure. The amount put in the letter, when we go to paragraph 5, it talks about what they are willing to give him, and it's $146,000 a year for the first 3 years, a little bit more maybe after year 4. But by year 5, Children's is not agreeing to pay him anything for his salary. Nothing. And so the question is, what was Children's obligation and what was Dr. Ma's obligation in exchange for the support he was receiving from Children's Hospital? And it was at a minimum that he had to apply for grants and get grants to fund his salary.
So
Otherwise,
let me
you're
ask you
changing
this.
it.
I'm looking at the chart in your brief.
Sure.
And this indicates that in 2008, which is the first data point on here, he was at 50%. And 2008 was right after the contract was re-upped in 2007. So, like, was he already below the 70% line at the time that he was persuaded to stay in 2007?
The evidence in the record as to what his funding was in 2000, there's no evidence in the record as to what his funding was in 2007. I would argue they renegotiated his contract at that time in 2007. This court has already found that that was a renegotiation of his contractual terms in the first decision. And so that 50% didn't include the resources that Children's were put in that letter, that $150,000 a year to fund his lab and salary that were in addition to his external grants. So it's a different analysis. But I want to be clear, the record about what other researchers did in funding, Children's has always taken the view that there are going to be times when you might lose funding. It is for a year or two is the language. Children's would fund maybe for a year or two. There's language in the contracts about applying for internal grants on a competitive basis. It's called the bridge funding. If there's no reason to apply on a competitive basis because you automatically get it, that language would look very different in those letters. And what Children's has said is some people may lose funding for a year or two. Dr. White is very clear that Dr. Ma was a distinct outlier. When you go back and look at his testimony, pages 62 to 64, he testifies in great detail about what he did for everybody in his department. He went back and looked at their funding for a long period of time. June Ma was not meeting his contractual obligations for a 10-year period. And during that time, he wasn't trying to meet his obligation to sustain funding. He was researching, and nobody else is the equivalent of June Ma within the department. That's what we've been told. Now, I'm not saying that you can necessarily look at the comparators either, because I think...
Well, I was going to say, isn't that their second assignment of error, that the trial court didn't do that?
Well, there's no evidence in the record about what the comparators are. There's no evidence that there is somebody that is the equivalent of June Ma in the record. Dr. White said there is nobody like June Ma. There were people who lost some funding for a year or two. A 10-year period, that's what Dr. White says. There is nobody like him. And so then the question is, what did Children's have the right to do under that circumstance? And if we're looking at the law and there is a breach of contract, you're always permitted to terminate the contract. And there's nothing that shows that anybody, to your question, Judge Kinsley, there's nothing that shows that Children's went in and said, if you don't meet your contractual obligations forever, you can just stay here and we will pay you $190,000 a year. There was never any back and forth. When you look at the record, it's solely June Ma saying, this is what I believed it to be, and not I had communications with anybody, that anybody from Children's conveyed that message. The other point on Dr. Deegan, that's testimony that's referenced a lot. Dr. Deegan was not responsible for reviewing any researchers after they made tenure. She had no knowledge about what their funding requirements were after they made tenure. But when she ran out of research dollars, she went in and renegotiated her job responsibilities so she was 100% administrative. So she wasn't going to, her view of what could happen was very different from Dr. Ma. She went in and said, I'm out of grant funding. Can I do something else so that I can keep my job at Children's? And they said, yes, you can be an administrator. Dr. Ma's view is he could just sit back and do nothing and get paid $190,000 a year.
But, so this chart you have in here, your opposing counsel said that that is salary, correct? And that his lab was funded.
Correct.
So this chart is about just his salary.
Just his salary. Correct.
So when you're saying that he didn't get any funding, you're talking specifically about his salary.
So, yes, but so Dr. Ma, at the time he was fired in July of 2016, his grant to fund even his lab was going to run out in 6 months, and he had no additional funding. So within 6 months of, I believe it's 6 months of the time he was fired, in 2017, he was out of grant money to fund his lab and his salary.
But
The
at
chart.
But at the time that he
Yes.
was fired, his lab was fully funded.
His lab was fully funded. It had shrunk down. He had reduced his,
And what's the rough numbers on that? Like, what are we talking about in terms of like, how much is fully funding his lab?
how much was his, I don't know the exact, I believe it was several $100,000 a year to fund his lab. His lab was unique because it's a wet lab, which means he had fruit flies and animals, so they had very specific obligations that you have to comply with under the law for research like that. So it is an expensive lab to maintain.
But so
if
I think just coming back to the big picture, like, if he's funding this multiple $100,000 lab, and that lab, whatever is happening there, presumably inures to the benefit of children's, like, can we look at it in isolation, the fact that his salary is not being fully funded?
I think you're not looking at it in isolation. You're looking at it with the terms of the agreement that Children laid out. Children said, we will give you $146,000 the first 3 years going back in 1992, and in 2007, they said, we'll give you $150,000. And the language in there is very clear, to cover the portion of your salary not covered through external grants. And so Children's did not agree to commit anything more than that. After 2010, there was no money that Children's agreed to commit to his salary. And that has to be read as part of the contract.
What is your position in terms of the percentage of his salary that he needed to cover? Is it 70? Is it 100? What did he need to do in order to be in good standing?
70%. It's in his reviews. It's going back. That was the policy of the Department of Biomedical Informatics at Children's Hospital. That's in the record in all of his reviews going from 2008 to 2017. That's in Esther Jacobs' affidavit that the requirement was 70%. It was 70%.
Okay, and that was being communicated to him how?
It was being communicated to him in faculty meetings, in department meetings, and in his annual review. And in his annual review, if he thought that was not his requirement, he had the opportunity to push back, to comment on the reviews, to provide feedback. He never did that. He accepted that that was his responsibility. Children's is the employer of choice in the region for a reason. They were working with him saying, let's try and get your funding up. Let's see what we can do. And they said, try and hit 40%. He didn't apply for any grants that year. They told him, you need 2 grants from the National Institute of Health. He didn't apply for any grants from the NIH that year. And that's important because the NIH is the only grant funding agency that you can use grant funds for your salary for. So he wasn't doing anything to try and meet his contractual obligations.
Well, let's say that he did apply for the grants and didn't get them. And from what I've read, it's highly competitive. Would we be here today?
Yes. Yes. I mean, I'll give you an example. You have an associate that writes a brief, and they put some words on a page, and it does not meet the quality of work that you want. Children's, he is a highly valued researcher, and the obligation, and it's very clear, that was that he had to get external grants to fund his research. That's what it was, and I understand it was difficult. That was the relationship that they created. He was going to be highly compensated. He had a difficult job where he had to do high-end research that would be funded by the NIH. And if the NIH wasn't funding him, he wasn't going to work at Children's Hospital. And Children's wasn't going to pay him for research that wasn't valued by institutions like the NIH. That was the relationship that they created.
All right, Ms. Brandon, you're at your time. Thank you.
Thank you.
Mr. Mesbaugh, you have 4 minutes.
Well, we're not talking about the abstract here, and Dr. Ma is not someone who sat back on his laurels and did nothing. In fact, the record is clear that in his last 2 years of work, he applied for approximately 4 to 6 grants, and it is not unusual, sadly, that these grants are not always funded. That's just life as a researcher. But you don't get to be in that position unless the university trusts you, because they know based on your record, based on your character, based on your accomplishments, we have faith that you will eventually get these grants. That's no different for.
Do you know what the level of funding was in 2007 at the time?
Yes, let's look at 2007, because that's when he decided to stay at the university. His funding was 35% of his salary, 35%, and 100% of his research funding. So they didn't tell him, you need to leave, or you're in trouble, you're getting out. What they gave him was a promotion, a new lab. So then to say that 70% was the litmus test for a researcher is absurd. As a matter of fact, we presented to Miss Esther Jacob, I forgot what, Esther Jacob, I think, a whole raft of individuals, all of whom never came close to 70, never came close to 40, which is what Pete White said, June, you need to get you to 40. No 70. They did it as they wanted.
Council, did they have the 70% requirement in 2007?
No. 70 didn't come about until they decided to go with this at-will contract in 2014 or 2015, I forgot the exact year, and they put a new policy in effect. And that's when the 70% came about, and for years and years, none of those researchers, or very few of those researchers, making that, and everyone who testified in this case said that. And there were never any metrics other than the 70%, which came about well after Dr. Ma, 20, 25 years after Dr. Ma had been working there. So he was never an outlier or anything close to an outlier. The fact is that there was no requirement of 70% that made you leave the university if you couldn't make it. So let's get the worst case scenario. The worst case scenario is June Ma is not making any efforts to fund, and he has no funding for his research lab. What does Children's do? Can they fire him? No, they can't fire him, but they can shutter his lab because he doesn't have any funds to require it, and then they can take his salary and reduce it from 170 or whatever it was to nothing if they want. He had no requirement.
It sounds like a firing to me.
Well, no, he can go to work.
Like the person in office
No.
space, you go to the basement.
He's still a tenured professor, but he's not doing any work. But they have guaranteed, but that's just hypothetical. It never happened because he was always productive, not to the extent always in a sustainability, but over a course of time he was in comparison to all of his colleagues and in accordance with the rules and policies and expectations of the university. When they put something in his performance appraisal for, we expect you to do that, that's aspirational. It's not a contractual obligation. It's aspirational. And as a professional, he does his best to try. And sometimes he's successful, and oftentimes, 80% of the time, they're not with funding. It's a tough world. But he was doing his best to make it, and he should have been there and should still be there, but for the fact that the university, that Children's changed the rules, changed their obligations. And if you accept Children's explanation for this, the contract is basically illusory. In other words, we'll assign what goals we want. If you don't make it, we'll change it. But there's no contract which says that's the case.
Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you all have a nice day. All right, counsel. Mr. Hoffman,
Yes, sir.
how much time would you like for rebuttal?
I'd like to reserve 5 minutes for rebuttal.
Okay, great. You may proceed when you're ready.
Thank you, Your Honor. May it please the court, Mr. Cousins. This is an appeal from a conviction for domestic violence. The bench trial, there was a self-defense defense, and and my claim is that the conviction is contrary to the manifest weight of the evidence. I want to begin by stating that seeing and hearing evidence, testimony is not a standalone or the sole criteria for judging credibility. Other factors must be considered, such as the consistency of the witness with her own testimony or with other witnesses. Motive should be considered, and also, and as applies to this case, the witness's believability should be considered in assessing credibility. Believability is based on common sense and asks whether the nature of the circumstances as a whole are likely within the range of possibilities.
Mr. Hoffman, I guess this is not the first domestic violence case that we've had where there's a claim of self-defense, and a lot of times there are inconsistencies across the testimony. There may be a history of bad blood or feud between the parties. What takes us out of the heartland of all of those cases and says that this is so significant that we should reverse on manifest weight grounds?
Well, one is that the trial court made findings where the court explicitly indicated that it was relying upon its ability to hear and observe the witnesses. And although that doesn't exclude the possibility that other things were considered, that was an explicit basis, the only explicit basis that the trial court used in assessing credibility. And in this case, there were only two witnesses. The prosecuting witness testified and my client testified. And Ms. Turner, Saritha Turner, was the prosecuting witness. And the trial court considered the unusual things in its findings. It indicated that it considered the fact that when she tried to maintain eye contact with my client during the oath, that he wouldn't keep eye contact with her. And if you think about that for a minute, staring at somebody is sort of, usually it's considered confrontational. I don't think it's unusual that he might divert his gaze from the trial court if she's looking at him while he's taking his oath, the defendant in a criminal case. The trial court didn't mention things that were very important in this case. Ms. Turner testified that, my client had dreads, and she testified that she actually broke off a dread while falling to the ground after being pushed. And the likelihood that she could reach after being pushed and while falling to the ground, reach a dread it's improbable, it's impractical. Another thing she said was that she didn't lay a finger on him prior to she called it being thrown, that she didn't touch him. And so, in other words, she wasn't pulling on his hair prior to being pushed away, but being thrown away. But she testified that this was very unusual character-wise with him. He had never acted this way before. But yet she said that this push was not to keep her from pulling his hair. It was just out of the blue, the throw. I keep calling it a push. She said she was thrown. She was inconsistent in her testimony about the second instance of being thrown. She said on one hand that it was because of the intensity of my client's addressing her daughter, but then later in her testimony on page 43 and 44 of the transcript, she said she was trying to get away when she was thrown the second time. So these are things that make this case unusual. The trial court's findings, relatively unusual findings, and also the fact that the testimony was illogical and impractical. And based on the Montgomery case that I cited to the court, that can be a basis for reversal if the trial court is relying upon its ability to hear and observe witnesses and testimony. That's not the end of the story. Believability must be considered, and my position is that it was not considered in this case. So Ms. Turner may have appeared to be sincere, but my point is her testimony was so unlikely that it was not within the range of known probabilities. It wasn't credible, and the trial court should reverse and order a new trial. If there are no further questions.
Thank
Thank
you.
you.
Mr. Cousins?
Good morning, Your Honors. May it please the court. The sole assignment of error here is that the trial court's finding was contrary to the manifest weight of evidence. There's really only one issue at play here, and it is if the defendant, Mr. Gibson, acted in self-defense. The definition of the case State v. Williams, a 2020 case from the First District, enumerated self-defense as an affirmative defense consisting of 3 elements. The proponent is not at fault for creating the situation. The proponent had a reasonable belief that he had to use force to defend against imminent use of unlawful force. And third, that such force used was not likely to cause death or great bodily harm. The case of State v. Reimer, another First District case from 2021, held that these elements are cumulative. If one of them is not present, then there can be no self-defense claim. The defendant at the trial level has the burden of production or producing evidence to show that he's made a prima facie case of self-defense. Cases of State v. Petway and State v. Williams have established that the state then maintains the burden of persuasion in that the state must disprove one of the elements beyond a reasonable doubt.
So what about Mr. Gibson's argument that logical inconsistencies in her testimony just kind of cry out for manifest weight?
Your Honor, I don't believe that I believe that her testimony was quite consistent throughout this matter. I think it's quite consistent, quite believable, and I think it is commonsensical. She states that when she was tossed to the ground the first time, her hand got caught in a dreadlock. Dreadlocks are generally longer strands of hair. I think it's quite consistent that if you're being tossed, your hand could get caught in one and pull it out or break it off. I think that's quite consistent and quite logical. Appellant cites to this the Montgomery case, which is factually dissimilar to the case at issue. This is State v. Montgomery is a 2015 case out of Claremont County. And in Montgomery, the trial court's findings were impractical and so illogical that it was not, that it was not credible. And in that case, the facts that made it so extremely uncredible is that defendant in the Montgomery case stated that, not the defendant, the state's witnesses stated that the door of the home that the defendant entered swung open after he knocked on the door. That doesn't happen. You cannot just knock on a door and it will swing wide open. Additionally, there was testimony from state's witnesses that the assault was extensive. State's witnesses said that he was punched in the face, called out for his wife, and the assault lasted for a period of time. Additionally, they found that the state's witness was several years younger than defendant and much larger than him and was unable to fight the defendant off. Additionally, there was another state's witness whose involvement was completely illogical. stated that a Mr. Seal, who was involved in this case, tackled the defendant, Mr. Montgomery, and pulled him down and ejected him from the house. And he said that he would only let the defendant go if he was told, if he would agree to get out of the house. I think here is what the biggest issue is in this case. The court largely avoided making any statement on credibility or how it assessed credibility in the Montgomery case. In the case at hand, Judge Russell explained her reasoning on the record for why she found the defendant guilty, including her reasoning on body language. In the Montgomery case, there was really nothing.
Is it appropriate to discount credibility if the defendant doesn't look you square in the eye?
Well, Your Honor, that's not necessarily. I can see other reasons for that, but ultimately, I think what it comes down to is the testimony was not illogical here. I do not think it was. It's not as illogical as the Montgomery case. I think that is the ultimate issue here. Regarding the element of self-defense here at issue in the current case, the first element is that the defendant, or the proponent, the defendant cannot be at fault for initiating the affray. The record is pretty clear here that the defendant followed his children out of the house while intoxicated, approached the vehicle in which his children are in and Ms. Turner was standing outside of, and charged at the vehicle. She positioned herself between the vehicle and him, and he began to pound on the doors, on the windows of the vehicle, and was yelling that he was going to beat his children. I think it's very clear that nothing would have happened here had he not exited the house and charged at the car. I think that clearly has been disproven beyond a reasonable doubt that the defendant was at fault for creating the offense. He was at fault for creating the offense. Second, I think this is also a very important point here. The defendant had to have a reasonable belief that he had to use force to defend himself from imminent unlawful force. Here the facts differ a bit as to what the parties testified to, but what the record is clear on from testimony from the victim and the defendant is that the hair, Mr. Gibson's hair was pulled out when Miss Turner was going to the ground for the first time. She was tossed and then the dreadlock came out. She says that it was because her hand was caught in his hair. Further, before the first encounter, Mr. Gibson, by his own admission, stated that he was ignoring Miss Turner prior to this encounter. Therefore, he couldn't have had a belief that, or be in fear of harm if he was indeed ignoring her leading up to this encounter, and he was really just yelling through the car window at his children. He couldn't have a reasonable belief that she was going to cause him imminent physical harm if he wasn't even paying attention to her. And at no point on his direct examination or cross did he say that he was afraid that any harm would come to him. And he testified, and that was never entered into the record. Third element, is that the defendant couldn't have used harm that was likely to cause, used force that was likely to cause imminent, serious bodily harm or death. He tossed her to the ground. She pulls out a dreadlock. I don't really think that element of self-defense is of great impact here, as I think very clearly the first two elements have been disproven beyond a reasonable doubt. Your Honor, I don't have any further argument unless you have questions for me.
No questions. Thank you.
Thank
Thank
you.
you, Your Honors.
Mr. Hoffman?
My client's, Mr. Gibson's story was only that, his testimony was only that that Ms. Turner was pulling his hair prior to him pushing her away. He didn't say that she actually broke off a dread prior to being pushed. But his testimony was that she was pulling his hair and he was trying to get her to stop it. I think there are tests and case law sanitizes what is in real life. It categorizes conduct, but things can be a mess out there, and it was reasonable for him to try to. His story was more reasonable, much more reasonable, in that it was reasonable conduct to try to push this person away who was trying to pull his hair. And Ms. Turner's explanation of how that dread was broken off, it's.
Is pulling hair sufficient to trigger self-defense?
Well, I think that it does if the self-defense is just pushing the person away from you. I don't think you have to put up with having your hair pulled by a person and them behaving that way. Again, the tests for self-defense makes it seem like it only would apply to extreme conduct, but I think it can apply to everyday struggles and fights and confrontations. And in this case, everything's sort of ratcheted down, according to my client, and it would apply. There was no way that a person, after being pushed away from another person, could still reach their head. They just can't, unless if they're like Mr. Fantastic or some character in the comics. And I admit that the facts aren't as extreme as they are in Montgomery. But Montgomery stands for the fact that you don't have to put up with illogical and impossible testimony just because a trial court was able to see and hear the witnesses. You don't. I don't know how much latitude a trial court has to be afforded in its findings, but if it makes findings that are just based upon how the witnesses look, and even during an oath, which is extrinsic to the testimony, I think it goes too far. My client didn't say he was intoxicated. He admitted he was slightly intoxicated, a buzz. And this daughter that he was trying to discipline wasn't with him. She wasn't one of the children that were being exchanged. She was already with her mother, and he felt he had to discipline her, and this was his chance. It wasn't like he started to discipline this person after.
How was he exactly going to discipline her?
Well, he was using strong language that he was going to whip her ass, but that's how people talk. I mean, that's...
Well, right, but and the mother's trying to intercede to prevent the physical confrontation, right?
Well, but the daughter's in a car with the window up, and he's tapping on the window. I think it was blustering. I think he would never... Well, that's the way he would talk. I mean, that's the way he talked. And so that's all you have is talk. There was no indication he was going to open the door and pull her out of the car. And then one more thing is, it wasn't so much that he was ignoring Ms. Turner at the time of the actual confrontation. He was addressing her. He decided the daughter started speaking up, and then he changed his address. He began to address the daughter instead of her. That's what his testimony was. And then then Ms. Turner got between him and the daughter, and then that's where the confrontation took place. And so, fear. I don't know if again, the tests for self-defense may not fit nicely in the conduct, but he testified she was pulling his hair at the time he pushed her away, and that is a reasonable rendition of this test of the facts. There were credibility problems with Ms. Turner, and the fact that she never really explained how the dread was caught when she used the word caught, accidentally caught on her as she was falling to the ground. She didn't even say she was reaching for it. I mean, the testimony was impossible, and I think that my client should have a new trial the conviction should be reversed as contrary to the manifest weight of the evidence. Thank you.
Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day. Okay, the final case to be argued today is State v. Hill. Ms. Peters, you may proceed. How much time would you like for rebuttal?
I'll reserve 3 minutes, please.
Okay. You may proceed when you're ready.
May it please the court, my name is Laura Peters, and I'm here representing Maisha Hill. This case involves an assault between former neighbors who, as the trial court said, admittedly didn't like each other. The question in this case is really which version to believe, as they tell somewhat drastically different tales about how the altercation occurred. But there's enough similarities actually in them to question why the trial court said, well, I don't find this believable, but I find the prosecuting witness's tale believable. But first off, we need to talk about the first assignment of error is Bridget Green invoking the Fifth Amendment right to not testify.
Counsel, there was no objection, correct? At trial?
Objection to?
To the trial court permitting this witness to plead the Fifth?
Well, the trial court is the one who did initiate this discussion when, like, the defense counsel called Ms. Green to the stand. And the trial court said, wait a minute, is this the one that everyone has said was the candy lady?
Yes, I read the transcript, I understand that.
Yeah, no, I'm just, just trying to build up. It's interesting because the trial court, in saying, makes a connection that the evidence doesn't. She said, so the trial court is saying, well, I'm concerned here because you all accused her of selling things out of her house, including drugs. Now, the defense never made that accusation, and actually, Ms. Wales, the prosecuting witness, never actually testified to that. So the connection between what Ms. Green sold and the drugs actually isn't in the record. It isn't there. What happened is Ms. Wales said, she was asked, do you know the candy lady? And she said, yes, and that was Ms. Green. So she goes, and she's the candy lady because she sells various things out of her house. And it was, yes. Then you go like 2 pages on. So that initial testimony occurs on page 18 of the transcript. And then on page 20, she's actually talking about how she knows Maisha Hill and whether or not she goes, I don't really know her. She was my neighbor. I used to give her things. I would go to Ms. Green's house and get her things, and she uses drugs, meaning my client uses drugs. So there was actually no connection. She wasn't making a connection that Bridget Green was selling the drugs, and that, because otherwise then Ms. Wales is implicating herself as supplying my client with drugs because she would, so the connection isn't there. So it's the trial court's faulty recollection, and so she's the one who, in essence, puts a fear into the prosecuting, into Ms. Green that.
But again, there was no objection.
I mean, I think counsel did question, I don't know, did she say, I object? No, but she was like, but we didn't, I don't see that connection. We were just saying she sold things, so.
But I think the problem, though, is, like, let's say the trial court was erroneous in that and should not have taken this measure. Without some sort of proffer, without some sort of actually asking the witness specific questions and having her invoke her Fifth Amendment right, like, how can we distill the essence of that testimony?
Your Honor, actually, the state makes a point and cites to State versus Smith in their brief about that you have to make this proffer. But the proffer, actually, if you look at State versus Smith, which is from the 10th District, the proffer isn't the proffer of the testimony, it's the proffer of the questions.
Right.
So then, in State versus Salazar, the 10th District, a couple years later, says, well, you know, because you can infer what the questions are going to be based on what questions the defense asks the other witnesses. So you're allowed to infer, like, it's going to be, the questions are, she was starting to ask the questions are, do you know Miss Wales? And then she pleads the Fifth. Well, there's nothing in that question that could have linked her to a crime. Was she at your house that day? I plead the Fifth. Again, nothing is linking the witness to a crime, but she's being allowed to invoke the Fifth Amendment. So
let me ask you, ma'am, there was, despite the implication that the candy lady sold drugs, my recollection was the prosecuting witness felt that the candy lady had set her up as well. So she may have been concerned not only about the possibility that she sells drugs, but also the possibility that she was complicit in this assault by luring the prosecuting witness to her house, and then, you know.
Ms. Wales does make a statement about, an isolated statement saying that she thought maybe Ms. Green had set her up.
Well, let me stop. I may agree with you that whether she knows the candy lady or whether she was at her house or whatever those questions were, they're fairly innocuous. And but at some point, I'm assuming the defense attorney was going to get the meat of the cross-examination, which is, at least in my mind, the two implications we just discussed. So if there was error on the part of the court, do you think it's harmless error? Do you think it's reversible error? How would you classify that?
I would say it's reversible error. It could not be harmless because in this situation, as we said, we have Ms. Wales' story of how this occurred, and it occurred inside of Bridget Green's apartment with my client suddenly opening up the screen door, grabbing her hair, and then hitting her with a black object, or in the presence of Bridget Green. Whereas my client and the witnesses that her boyfriend and her friend, Ms. Hunter and Mr. Cooker, testified to that this all occurred outside of Bridget Green's house, and Bridget was there. So the only person that both parties agree was present for the altercation was Ms. Green. So I would think that her testimony would have gone a long way to saying which side is more believable. And in this case,
Well, but the
she was going to testify for the defense.
The trial court said something about the three witnesses being wholly unbelievable or something like that, or inconsistent.
The trial court, yes, made a statement that there were 4 different stories, and that's not actually, I don't believe that's accurate. She's taking, the prosecuting witness, the defendant, the boyfriend, and the friend, as all telling 4 different tales. But there actually isn't that much inconsistency in between my client and her witnesses. The major inconsistency, and the only one that the state alluded to in its brief, is who drove the car for them to get there. That's the major inconsistency, but that doesn't mean, that has nothing to do with the events that happened. They all agree that my client went to go check the mailbox, and that the other 2 went to go to Bridget Green's house. And it was on her way to Bridget Green's house that my client says that Ms. Wales came up behind her and threatened her with a knife, and the fight ensued. So Ms. Green, if she testifies that way, she's the godmother of the prosecuting witness. She's a friend of this. So she doesn't have any interest in this, because both sides mean something to her. She knows, Myesha Hill, the other, Miss Wales is her goddaughter. So I think that's why her testimony would be important. And if you look through, turning more to the manifest weight, then how the trial court summarizes the testimony of the defense witnesses. If you actually look through and correspond it to what they actually testified to, you'll see that the summary is incorrect. So she'll say, that Ms. Hunter testified that she saw Myesha walking to the mailboxes and that Ms. Wales was following her. That's not true. That's not accurate. That's not an accurate summary of Ms. Hunter's testimony. She'll say that that she was confused by Myesha, or she would actually say that, it doesn't make sense to her that Myesha Hill would turn her back on someone who was threatening her as she was checking her mail. They both had but that same problem also exists in the prosecuting witness's testimony. She says Myesha came to the door, threatened her with, come out and fight me, and she turns her back on Myesha to talk to Bridget Green. So why is Myesha turning her back unbelievable, but it's believable for Ms. Wales to do so?
Well, wasn't one through a door and the other not?
A screen door. So, and she said then that my client opened up the screen door and grabbed her hair and was trying to pull her out. But then her own testimony isn't consistent internally. At one point, my client is gripping her with, holding her hair, and another time, and she breaks herself free, and then my client goes out and grabs an object, an unknown object, which she couldn't see when it strikes her right in the face with it. And then another story is my client was grabbing her hair, and she pulls Myesha into the apartment. So how does she go get the black object from outside? So based on all the inconsistencies inside the prosecuting witness's testimony, the failure to really investigate whether or not Ms. Green should have properly invoked her Fifth Amendment, and the trial court's faulty recollection of the evidence of the defense witnesses, we ask that you reverse and remand for a new trial. Thank you.
Thank you. Ms. Wood?
Morning, Your Honors. May it please the court and counsel. The issue that we have in this case today is an issue of whether or not the witness, Ms. Green, properly invoked her Fifth Amendment right. State is arguing that she did properly invoke her Fifth Amendment right, that the court did not commit an error by allowing her to do so. Even if this court were to find that it was error, any harm that resulted from that would have been grossly overcome by the court's finding that the defense witnesses were incredible, and that there is no reversible error in this case.
How do we evaluate that harmless error if this is a credibility battle and the trial court is making credibility determinations, but this witness could have, we don't know whether she would, could have tipped the scales on that?
Your Honor, I believe that in the best case scenario, the testimony of Ms. Green would have only been to corroborate or to line up with the testimony of the other three defense witnesses that the court found was incredible. Even if there was a situation where Ms. Green's testimony completely contradicted that of the defense witnesses, that too weighs against the defense in any finding that this conviction is against the manifest weight of the evidence. There was no situation in which.
Well, but I mean, at some point, like if you have multiple witnesses and the trial court discounts them, but then like another witness comes in and corroborates that, or another witness comes in and corroborates that, eventually there's going to be a tipping point where the trial court says, maybe I do believe them now.
And I don't know that necessarily if it would have been Ms. Green, that one witness in the face of other three, in light of all the inconsistencies in the testimony of those defense witnesses, which the trial court did point out, the testimony of Ms. Green would not have been enough to make that tipping point, to make the defense's story or version of these events any more believable to the court. In terms of the Fifth Amendment right that Ms. Green did invoke, defense counsel claims that there was not enough of an inquiry by the court into the reason why Ms. Green believed that she would be at risk of incriminating herself in a criminal act. In this case, Your Honor, there was an inquiry, though not necessarily well, what's being offered, there's no proffer, I believe, as you yourself pointed out, Judge. There's no proffer by defense counsel at any point to go into the questions that are potentially going to be asked of Ms. Green or the answers that are expected of her testimony. There's nothing for the trial court to work off of and for Your Honors to work off of other than what had been presented at the time that Ms. Green invoked her Fifth Amendment right. And at the time, what the court was aware of was that Ms. Green was the proverbial candy lady. There had been testimony from both Ms. Hunter as well as from Ms. Green, from Ms. Wales, that Ms. Green, for example, sold cigarettes out of her house. That's an illegal act. So at some point in her testimony, she's potentially going to say, on or about this date, she sold or gave cigarettes to one of these people that were coming over to her house, potentially incriminating herself in the crime of selling those cigarettes out of her house illegally, if that's what she's in fact doing. She's describing to whom she's selling those items. You know, she's providing information or could potentially be providing information in her testimony that could be used to later incriminate her in a crime.
And isn't it the trial court's duty to inquire about the witness's justification for pleading the Fifth?
And I believe that, there wasn't a specific order of, asking why are you going to plead the Fifth. There's not that specific inquiry here, but the trial court does, in the presence of defense counsel as well as in front of Ms. Green, explain their reasoning for the concern.
Isn't she supposed to ask the witness? Shouldn't the trial court ask the witness about the justification for pleading the Fifth?
I think in this scenario, no, because the court did express the specific reasons for its concern, explained those to Ms. Green, then called up an attorney who then came up and spoke with Ms. Green about the potential risks that she could face. If it had been a situation where the attorney talked to Ms. Green about whatever it was she was supposed to testify to, and they determined that there was no risk for her to testify without incriminating herself, Ms. Green could have got up on the stand and done so, and the court would have then have its concerns assuaged.
But I guess my concern is just looking at the first couple of questions that are asked that certainly don't seem to elicit any sort of incriminating information. How's the trial court letting her get away with that?
I think the questions that were asked were, and correct me if I'm wrong, but one of the questions that was asked was whether or not these individuals, whether or not Ms. Hill was at whether she knew Ms. Hill, whether Ms. Hill was at her apartment on the day of this incident. And Judge Winkler, I think you pointed out, there had been an insinuation in the prosecuting witness's testimony that Ms. Green had in fact been the person to set up this altercation between Ms. Wales and Ms. Hill. So even just that question of, do you know Ms. Hill, was she at your apartment, those things could potentially be used if she was in fact complicit in arranging for this confrontation or assisting Ms. Hill in arranging this confrontation. Even those questions could have potentially been used to incriminate her in her complicity with this, at which point she then invoked her Fifth Amendment right and chose not to answer that question. I believe the court, in explaining its reasoning for why it had concerns, and then Ms. Green invoking her Fifth Amendment right, kind of leads to the conclusion that there was something in her testimony after being advised by counsel that she would have been at risk for.
Okay, so as your opposing counsel points out, the trial court brought up drugs.
Correct.
When it comes to the candy lady, but that wasn't in the testimony.
It was not in the testimony, Judge, but there was I don't think the drugs was the only consideration here. I think that's what everybody looks at is, oh, that was never said. But the other consideration, selling cigarettes to people out of your house is also an illegal act.
Is she going to be prosecuted for that?
I don't think it's the question of whether she would be prosecuted. I think it's the question of could she be? And the answer, I think, would, yes, she could have been. If she's identifying the date and time that she did, in fact, sell
I
cigarettes.
admit that I'm jaywalking. Am I going to be prosecuted for that? I mean, I think that's what I struggle with. Like, it's one thing to say, like, oh, there's evidence that suggests you're a massive cocaine trafficker, and maybe you should talk to a lawyer about whether you should testify or not. But, like, selling some cigarettes, like, that just seems...
And I understand that concern. However, I do think that when you're looking at the case law, the concern is whether or not there could be a potential for incriminating yourself of committing some kind of criminal act. And I do think that, again, if that is the concern and the court does find that there was error in not inquiring further, any error in doing so, as discussed before, would have been harmless because of the incredulity with which the court viewed the testimony of the other defense witnesses in this case. Yeah, and just more to that point, it wasn't just that she found them to be incredible. The court pointed out specific reasons why each of the defense witnesses was incredible. All three people at one point claimed to have been driving the car. The two other witnesses, Ms. Hunter and Mr. Coker, said that they were driving away to go to Ms. Green's apartment and somehow still saw this altercation where Ms. Wales allegedly came at Ms. Hill with a knife. You know, inconsistencies in the story, impossibilities in the testimony of the defense witnesses.
Does
that
it
led
really-
to the
I mean-
conclusion that she was not present.
Does it really matter? I mean, I don't know how long between the incident and the trial. I don't know how long it was. But the very minor details about who was driving the car or, you know, exactly, you know, what position somebody was standing in, just, you know, they testified that they saw it. I'm struggling a little bit with how their stories were inconsistent because when I read it, I felt like their stories were fairly consistent. I mean, there are a few details, but overall, what am I missing?
And Your Honor, I do think that goes to when you're talking about a manifest weight challenge, the trial court being in the best position to view holistically the testimony of all of the witnesses. That's including pieces of the testimony. The court found that those details, those differences between the defense witnesses' testimony, the court believes that those were significant enough to find that they were not believable. The court found that the version of events where Ms. Hill was just going to check her mail and all of a sudden Ms. Wales, comes out of nowhere with a knife. The trial court found that version of events to not be believable. And it's an issue of manifest weight. The trial court is in the best position to evaluate the credibility of those witnesses. The court found that those witnesses were incredible, and absent some finding that there's a manifest miscarriage of justice and in the court doing so, there is nothing to reverse in that sense. And if Your Honors have no further questions, I will conclude here.
Thank you.
Thank you.
Ms. Peters?
Judge Bach, I'd like to pick up where you left off. I agree with you in that I do not think that the defense witness's testimony is inconsistent when you go to the heart of the assault that my client was charged with, whether or not, and to clarify something in the record, and I know Ms. Wood is pinch hitting here, like she's filling in at the last minute, so she may not be as familiar with the record, but Ms. Hill didn't testify that Ms. Wales came out of nowhere with a knife. She testified that she went to go check the mail, and Ms. Wales was sitting outside on her stoop, and they gotten into an argument. This is bad blood. There's already bad blood between the two of them over a dog, and so she decides, after checking the mail, she decides to go and head to Ms. Green's house. Doesn't want to engage Ms. Wales anymore. And then Ms. Wales comes up from behind her because, and as Ms. Wales testified on her own, she thought that the whole beef could be squashed if they just got into a fight. That's not my client saying that. That's the prosecuting witness. So whose testimony, so she thinks that the whole beef between them could have been solved if they had just gotten into a fight. So it seems more credible then that she's the one who is initiating the fight, that she's the one coming up behind my client and trying to begin an assault. And that's why the self-defense part, where we argue self-defense, plays into it. And also, going back to the Fifth Amendment issue, the selling, whether or not Ms. Green sold what she sold, is actually irrelevant, because Ms. Wales testified she went to Ms. Green's house that day to help her with her recertification for CMHA, because Ms. Green had called her a couple times asking for help. My client says she was there to check, came to the neighborhood to check mail and to visit friends. No one was actually saying that they were going to buy anything from her. So again, she could have been allowed to testify about the events that occurred, and no one really needed to say anything about what she sold or when she sold things. And finally, I know that the trial court didn't pick up on, doesn't seem to pick up on, Judge Winkler, the fact that Ms. Wales said she was going to be, that she believed Ms. Green set her up. But she also said that in connection with, I'm going to stay at your house because I believe you set me up, and I'm going to call the police. Is that what Ms. Wales did? No. She went home, and that's when she called the police. So I think she's making some things up at trial. So we would ask that you reverse and remand for a new trial. Thank you.
Thank you. Thank you both for your arguments today. The case will be submitted. We'll get out a timely written decision. Hope you both have a great day.